Hey guys, today we're talking about the Articles of Confederation and the Constitution. Those are two of the early documents that set up our country and the government of our country. The first one being the Articles of Confederation, and then the Constitution came along after that. What we're doing today is we're doing the learning objective of comparing and contrasting different political ideals. The Articles of Confederation and the Constitution are very different documents. The way it worked was 1776 was when the United States went and declared independence from England. After the United States declared independence from England, they obviously had to fight England and to try to kick them out of the country. Once they were able to do that, the first government that we set up was based on something called the Articles of Confederation. The government of the United States did not want to have a very strong central government like we have now. So what they did was they gave a lot of power to the states. Each state had the power to govern itself in many different ways, and therefore that did not exactly work. So I want you to say right now, I want you to write the note that the Articles of Confederation was a failure. Please write that in your notes to the right. It took 10 years to figure out that this was just not going to work. So even though we had a Declaration of Independence in 1776, we did not have a constitution until 1787. So for 10 years, the Articles of Confederation were used to govern the country, and for 10 years, they had lots and lots of problems using it. So the new government was the Articles of Confederation. It set up the first government of the United States. The Articles of Confederation was a document that gave a lot of states' rights to individual states. So if you think about the 13 colonies, each one, in a way, acted as their own country. They had the right to have courts. They had the right to tax their citizens. They kept their own militaries. They had their own laws. They had their own money. It was definitely almost an every state for themselves kind of thing. The Constitution was written to replace this government with a new government in 1787. So there were two groups of people that were established during this time. The people that were the Federalists and down here, and then the Anti-Federalists. The Federalists were the people that definitely wanted a stronger central government. They thought that the central government should be able to make laws to affect the people of all 13 colonies, and that was the only way that the government was going to work if we had a strong central government. Then down here you have the Anti-Federalists. The Anti-Federalists were the ones that essentially were responsible for the Articles of Confederation. These people were very afraid of a strong central government. If you think about it, it was because we had just kicked England out of the country. When we kicked England out of the country, we were afraid that we would develop a government that was just like England. They were a strong central government. They told the people what to wear. They told the people how they were going to be taxed. They controlled a lot of the day-to-day lives of the people of the United States. The Anti-Federalists didn't want a strong central government because they thought they would create a government just like the one that we fought against. So they were against having a strong central government, and they wanted to employ the Articles of Confederation. So what did the Articles of Confederation do versus the Constitution of the United States of America? The executive branch, the President of the United States. Obviously, according to the Constitution, the executive branch is the President. According to the Articles of Confederation, the national government did not have a president. We did not have a president under the Articles of Confederation, and we did not have an executive branch. Under the Constitution, currently, we have a president, and he is elected, or she, excuse me, is elected by an electoral college. In other words, people do not vote for the president. People cast their vote, and electors vote for the president, and that's currently the way it happens. The way that works is, therefore, a majority of the citizens don't necessarily vote for the president, and a minority can actually vote the president, which we've seen in the current election. Remember, Donald Trump did not have the majority of votes. He had the majority of electorates, and therefore became the president. The president can provide a check on powers of legislative and judicial branches. Most notably, the president has veto power over laws. So write that in your notes to the right. The executive branch and the president has veto powers. the judicial branch do? The courts. So we have three branches of government: executive, judicial, and legislative branch. I'm sorry. So we have the judicial, legislative, and executive branch. Those are the three branches of government that we have right now. In the Articles of Confederation, the judicial branch was handled in a different way than we do now. The national government had no judicial branch. So in other words, we did not have a Supreme Court. Today, if you want to, what you can do is argue your case in court. If it gets denied or if it doesn't turn out the way you want, you can appeal to a higher court, which usually means the Supreme Court of your own state. If, for instance, you go to your own state and it still doesn't give you the answer that you want, you can appeal the decision to the Supreme Court, which is the federal court. Under the Articles of Confederation, the national government had no national judicial branch. We did not have a Supreme Court. Each state had its own court system, and it ended right there. Under the Constitution, a system of federal courts headed by the U.S. Supreme Court is actually what's available. Each state still has its own system, but it also has the Supreme Court that can overrule the state's decisions if necessary. The legislative branch. This is the branch that writes the laws. Under the Articles of Confederation, the legislature of the national government was a one-house Congress, only one group of people. Each state, no matter what the population of that state, had one vote in this legislative branch. So every so often, every state would send one legislator, one lawmaker from the state to the legislative branch of Congress, and they would make votes on certain issues. This obviously presented a problem because some states had a lot of people in it and some states had a few people in it, so there was a mismatch there. So the Constitution had an idea to help balance this process. They had a two-house Congress, so the thing that was equally representative of everybody was the Senate. They set up the Senate and the House of Representatives. The Senate, no matter what size the state was, had two senators representing the people of that state. The thing that made more sense was to have a second body called the House of Representatives. In the House of Representatives, there are a number of representatives from each state, and it's based on population size of that state. The states with the largest population get the most numbers of representatives, so that way it's more equal. In order to pass a law under the Articles of Confederation, 9 of the 13 states must be in favor of the law. So that is a super majority. Getting 9 of 13 states to agree on anything in today's age or in the past is most likely not going to happen, and it really didn't happen back then either. So passing a law under the Articles of Confederation became very difficult to do. Under the Constitution, a majority is needed in the House of Congress, in each House of Congress. So the Senate and the House both must have a majority in order to pass a law. After that, the president must sign it in order for it to become effective. The president has a choice whether to sign it or veto it. So this was a lot easier to pass laws, and currently is still easier to pass laws, because all you need is 51%, one above 50% of the votes, and the law passes. Under the Articles of Confederation, the national government had no power to establish an army. This is another one of those things that the anti-federalists wanted to do. The whole point of this was a strong central government was not necessary, and therefore a strong central government army was not necessary. So the Articles of Confederation stated that the national government had no power to establish an army. The national government could only ask each state to send soldiers in order to fight a war, say against England or France or somebody like that. So the states still had the right to say, no, we're not going to send soldiers, or yes, we will send soldiers to defend our state. So if you really think about it, if there was like a military uprising in the state of New Hampshire, you would probably have a hard time getting states like North Carolina and South Carolina to send their state military to New Hampshire to help fight the war in New Hampshire. Most states would probably be like, no, it's not our problem, therefore we don't have to do it. So under the Constitution gave the national government the power to raise, establish, and recruit an army, and giving the president the commander-in-chief role. The president is the head of the federal military. Currently is. Taxation. This is the big one, guys. The Articles of Confederation gave no ability for the national government to power and had no power to tax. That means the government could not ask individuals from states for money. When you do this, you give up the ability to raise money for the government, for the federal government. When you do this, you also can't raise an army to fight against other countries, because what army is going to come fight for you if you cannot raise taxes? Those tax dollars pay for the army. So the federal government had no ability to raise a national army at the beginning of all of this, because the Articles of Confederation didn't allow them to do so. The national government can only ask each state for money to carry out its powers. And like I said before, each state had the ability to say yes or no to those stipulations. Under the Constitution, the national government had the power to tax everybody. We call it a federal income tax. Every paycheck that you get, part of that paycheck, a lot of that paycheck sometimes, goes to the federal government. The federal government uses that money to pay for programs and, of course, a military. Civil liberties, individual rights, life, liberty, pursuit of happiness, all that good stuff. Under the Articles of Confederation, there were no federal civil liberties. According to the United States of America, you did not have the right to life, liberty, and the pursuit of happiness. Each state could set up their own constitution if they wanted to and grant civil liberties, or they might not. So that was something that also was different among the states. Under the Constitution, there were no individual rights in the original draft of the Constitution. So what happened was it was left up to each state. However, each state did not ratify the Constitution. So in order to ratify the Constitution, several people who were writing the Constitution stepped up and said, no, 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 you need to have individual freedoms, individual rights, civil liberties written in the Constitution, or we're not going to sign it. And so they didn't have enough votes to sign the Constitution, so what they did is they added an extra 10 amendments to the Constitution. Those extra 10 amendments became known as the Bill of Rights. That grants you your civil liberties, the right to free speech, free assembly, free religion, your right to bear arms, your right to a speedy trial, search and seizure. All of those things that we know as our civil liberties are written in the first 10 amendments of the Constitution, called the Bill of Rights. Once they wrote the Bill of Rights, everybody signed the Constitution and therefore made it legal. Federalists versus Anti-Federalists, the first two groups of people that existed, the political parties of the United States of America from the beginning of the United States of America, were called Federalists and Anti-Federalists. We know them now as Democrats and Republicans, but at first they were called Federalists and Anti-Federalists. What the Federalists believed is a strong federal government. What the Anti-Federalists were anti-strong federal government, if you can remember it that way. A strong federal government is a very strong central government that consists of a legislative branch, an executive branch, and a judicial branch. And that's how we exist today. Anti-Federalists wanted to give all the powers to the states and therefore have the states govern themselves for the most part, with the federal government being very weak in the process. The Federalists supported removing some powers from the states and giving more powers to the national government. The Federalists favored dividing powers among different branches of government, so we had checks and balances. Each branch of government had the right to overrule certain powers among the other branches of government so that no one branch of government became too powerful. They also proposed a single person to lead the executive branch, a president, and that was the leader of the executive branch. The Anti-Federalists thought a little bit differently. They wanted important political powers to remain with the states. They thought the states had the right to govern themselves. They wanted the legislative branch to have more power than the executive. In other words, writing laws was more of an issue for them. They wanted people to be able to write laws, but the executive branch, they wanted them to be very weak. In other words, no president. They feared that a strong executive, like a president, might become a king or a tyrant. And remember, they just kicked a king out of the United States, so they were very anti-king, anti-major power. They believed a Bill of Rights needed to be added to the Constitution to protect people's rights. So it took both of these parties to come together on the Constitution. The Federalist obviously wrote the Constitution. The Anti-Federalist refused to sign the Constitution and ratify it and to become legal until it had people's rights written in it, which became the Bill of Rights.